Hey, everyone, welcome. Thank you so much for joining us here on Substack on The Breakdown. Welcome to my good friend, longtime friend. We've been covering stuff now, I feel like, for too long.
Is it a decade? I think it's a decade.
It's a decade now. I wish we were friends under different circumstances in a different
Mm,
timeline, but here
mm.
we are. This is Joyce Vance. She writes civil discourse here on Substack. I encourage everyone to subscribe to her newsletter. And today I wanted to get a little bit more of a legal deep dive. We sort of did this with what Orrin Kerr had to write for Lawfare over on the Unjustified podcast today. But I kind of wanted to get it out there in less wonky terms that everyone can understand because we're dealing with a bunch of precedent. So as you probably know by now, DHS issued an internal memo last May that has been uncovered and given over to Congress and whistleblower aid by two DHS whistleblowers. And what this memo does is it tells you to ignore the Fourth Amendment, ignore all your ICE training materials, and go ahead and enter someone's home and use force if necessary, using nothing but an administrative I-205 warrant rather than a warrant signed by a judge, a judicial warrant, which is traditionally, like it's in all their training materials, how you are supposed to go about doing that. And there's reasons for that, and there's a lot of court precedent about that. And so what we learned from that internal memo is that there was some Office of General Counsel decision made at the Department of Homeland Security that apparently gives the legal reasoning as to why you should be able to ignore the Fourth Amendment and go ahead and enter on an administrative warrant only. Now, I have filed a Freedom of Information Act request for those documents. I doubt I'll get them under deliberative process privilege, but I had to try. And so what I wanted to talk to you about today, Joyce, is to try to kind of guess what legal reasoning that Office of General Counsel at DHS could have possibly put forward to justify entering our homes without a judicial warrant. And there's a bunch here, and I kind of wanted to simplify it. We've got Abel from 1960 that's quoted in recently Kidd and Malagerio. And then we've got other Supreme Court precedents since Abel saying that you have to have a judicial warrant through three cases called Coolidge, Shadwick, and Payton. And so it seems like, and I'm trying to sum this up into layman's terms, that what DHS might be relying on is an old, non-dicta, non-precedent decision from 1960 in Abel that's been recently quoted in court cases, instead of these three newer Supreme Court decisions that have said that you actually do need a judicial warrant. So first I want to ask, why do you need a judicial warrant instead of an administrative warrant? Uh, from these three cases that I'm sure you'll talk about, why did the court say you have to have a judicial warrant? You have to have this signed by someone outside of the executive branch.
Yeah, so newer is not always better when you're talking about precedent. What really matters is whether you're using precedent that applies to your situation. And the granddaddy of precedent, when you talk about law enforcement entering someone's home without voluntary consent to enter, is the Fourth Amendment, which says that you can't be searched, nothing can be seized, unless a neutral magistrate judge finds that there's probable cause to believe that that search will, for our purposes, reveal evidence of crimes or fruits of that crime. And so here's I think in a nutshell what DOJ is doing. And I should say that Orrin is really considered to be one of the preeminent academics in the country when it comes to the Fourth Amendment. And he's done, I think, a masterful job here of guessing at what DOJ's rationale is. You know, my expertise, I too am a wonky academic, but I spent 25 years at DOJ. And for about 10 of those years, I was in my office's appellate division. I ran that appellate division for much of the time. And one of my jobs was to tell agents no, to tell them that if they wanted to do certain things, they had to play by the rules. So if this was a criminal case, which it's not, and an agency told me that they intended to enter someone's home without a search warrant, I would tell them, absolutely not. Not on our watch. You do that, we're not going to prosecute your case. and we're going to have a conversation with your leadership. That's pretty clear. This situation is a little bit different. This is some of the DHS agencies, ICE, ERO, possibly CBP too, saying we have warrants, we have orders from not judges, right? Immigration judges. That's not an Article 3 judge appointed by a president, confirmed by the Senate. That's an executive branch employee, somebody who's terminable at will by the president. And these judges have entered final orders of deportation. And I do not mean to denigrate those orders in any way. We can discuss immigration another day. The process is broken. Congress has failed to do its job in many ways, and the immigration judges are swamped. But when they issue these final orders of deportation, whether you and I might agree with the basis for those, they are enforceable orders. But here's the catch, and I think this is just the best way I can explain it in non-wonky terms. If you have an order to deport somebody, and if you see them walking down the sidewalk, you can take them and put them into deportation proceedings. But you cannot go into a house to do that unless you have a search warrant first. The argument that the DHS agencies are making is that it's sort of akin to a situation where you've got an arrest warrant and you know somebody's in the house, you've seen somebody commit a crime and run into the house, so you can go in after them to drag them out. And that's true in some cases. But let's take the example of the Hmong grandfather, the frail elderly man who was dragged out into the snow in his underwear. He wasn't even the person that ICE said that they were looking for at that time. They indicated that they had someone who had a final order of deportation. That gentleman was an American citizen. So they did not have a good faith basis for going into the house. And I guess at bottom, that's what this comes down to. ICE is operating in a way that they no longer, I think, are entitled to any presumption of good faith in what they're doing. DOJ has always operated in the courts with the presumption of regularity that says that judges presume that DOJ officials are being truthful and are acting in the way that they should. And that's out the window. And this is, I think, one of the most dramatic indications of that.
Yeah, in fact, I had asked Andy McCabe, who worked in the law enforcement part of it for over 20 years. And I said, well, how, imagine yourself wanting to go search a place and to be able to sign your own warrant to just go in. That's what these I-205 administrative warrants are. They're signed by ICE officers, not even the
They're not
immigration.
search warrants, right? They don't even purport to be search warrants. These are gives you the ability to detain someone who has a final deportation order.
Right, exactly. And there's no judicial person involved in it, which is and talk a little bit about this, why you need a neutral judicial person to sign this. So the precedent that we see in like Coolidge and Shadwick and Payton, where they determined why you have to have a judge's warrant and not a warrant signed by somebody else in the executive branch.
The Supreme Court's been very clear about this, and it just makes good common sense. When you have something as fundamental as people's constitutional rights at stake, there needs to be a neutral, objective, the language that they use as a magistrate, a neutral, objective judge who's determining whether or not the agency, part of the executive branch, is entitled to do what it says it's entitled to do. You want someone else making that decision, very much like the premise of having three branches of government and checks and balances. So the notion is, in essence, that someone who's playing on your team shouldn't tell you that you can go ahead and seize the person, that you have to have somebody else in the mix. And if you ever needed an explanation for why that's the case, it's exactly what we're seeing here. Exactly what we're seeing here.
Right. Just sort of like how the president shouldn't get to decide if he gets to stay in office and the check sits with the Congress.
I mean, can I just use you for therapy for like 30 seconds here and tell you how unbelievably frustrating this is, not just for me, for everybody from DOJ who I've spoken with in the last couple of weeks. There are obligations that you have if you have the enormous power that comes with being part of federal law enforcement. And one of those obvious obligations is to do everything you can to avoid violating people's civil rights. We often would talk among ourselves about that's too close to the line. Your obligation as a DOJ or a DHS employee is to avoid coming any place close to the line at which you might violate someone's civil rights, to stay well back from that. And what we're seeing now is government employees running straight through the line with the blessing of the DHS secretary and the president of the United States. And it's so not normal. And yet so many people seem to just not be aware of the utter breakdown of how this is supposed to work in the last months.
And is it possible? I don't even know if this is possible. I sort of get it a little bit, but when we talk about remedies for if ICE comes into your house without a judicial warrant, that's not really a crime. So if it was a crime, if somebody unlawfully came in and searched your house for a crime, you would make a motion to say that that evidence is fruit of the poison tree and we're not going to use it or dismiss the case or et cetera, et cetera. But for remedies in these civil proceedings, immigration is civil proceedings, the Supreme Court has been chipping away at something called the Bivens remedy. And that has made it extremely difficult, even though Kavanaugh says, well, if you think your rights are violated, just sue the government, which is why, we call it a Kavanaugh stop now. But talk a little bit about why it's so hard. Like, if you are someone who has a house and ICE has broken the door down and come in with an administrative warrant, not a judicial warrant, the remedies are now very limited to you to get any kind of justice for that.
We're so used to talking about the criminal side of the house, the criminal work that DOJ does. It's important to understand that in main justice in every U.S. attorney's office across the country, there are lawyers who do criminal cases and lawyers who do civil cases. And so let's say I'm prosecuting you and I do a bad search of your house and I seize evidence. The first thing that you're going to do is go to the judge and ask the judge to suppress that evidence that was obtained in violation of your Fourth Amendment rights. And that judge is going to dismiss that evidence. These are not close cases. If the warrant was bad, or if I did not have a search warrant and I walked into your living room and took whatever your contraband is, it's not going to be admissible at trial, with a couple of rare exceptions involving inevitable discovery and stuff like that we don't need to discuss right now. Civil cases, as you point out, are different. These folks are being seized and put into deportation proceedings. So there's never going to be a criminal case where they could move to suppress evidence. They're already subject to final deportation orders, at least theoretically. But maybe they're not. Maybe they're U.S. citizens, or maybe they're people with status to be in the United States. They're going to stick around. And then they can start to think about trying to get a civil remedy. That means that they can go into court and file their own lawsuit and ask for damages. If you bust my door down, and we've seen that happen, right, to go into these houses, those are civil damages that I'm owed, theoretically at least. But as you point out, this Supreme Court is not friendly towards Bivens actions. Those are the ways that the mechanism private citizens have used to ask the government to compensate them when their rights are violated by law enforcement officers acting under color of law. And that, I just have to say the court is hostile, and it's very difficult to imagine that cases of that nature would survive. And so I think the remedy that has to be considered here is whether or not there's some larger ability to go into court now that we've seen this memo and to ask for either a declaratory judgment that the agencies cannot enforce this memo, or some sort of temporary restraining order seeking a permanent injunction. One of the problems, though, is that the Supreme Court has recently frowned upon nationwide injunctions. And so little by little, they have really made it very difficult for people who want to protect the Fourth Amendment.
Yeah, agreed. In my personal lawsuit against the Department of Veterans Affairs for my unlawful removal way back 6 years ago, we still haven't gone to trial. I wasn't allowed to bring a First Amendment case for free speech because of Bivens. That's how I personally became aware of what Bivens was and the Bivens restrictions. Before I let you go, I just wanted to ask you, we all saw with our own eyes and heard with our own ears what happened on Saturday morning, and with the murder of Department of Veterans Affairs ICU nurse Alex Pretti, and we had FBI on the scene, and then they were told to leave, and DHS took over the investigation, and again, just like the murder of Renee.
Not FBI, right? With the locals, the state police in Minnesota.
Yeah, and they were trying to secure the crime scene, and DHS was telling them to leave, and DHS took over the investigation, not even letting the FBI in on it because I guess Kash Patel screwed up the first one screwed up the cover up of the first one. But uh, uh, you know, when we talk about supremacy clause and sovereignty of the state to investigate its own crimes and being blocked out of getting evidence in both of these cases, how likely is it? I mean, we did get that temporary restraining order very late last night from the courts blocking DHS, FBI from destroying or tampering with evidence. And kudos to those lawyers who worked all day on a Saturday and were able to secure that temporary restraining order within the day. But how likely is it? Does that set up for maybe a warrant to try to get this evidence from Minnesota? I mean, what does that even look like to try to get? Because I asked Andy, and he's like, "I've never seen it in the whole time I ever worked for the FBI. We've never iced out any local investigators." What does that look like? How do we make sure that justice is served and that local Minnesota authorities can actually conduct a neutral investigation?
So look, Andy is dead on the money. This is unprecedented. There is no precedent for the federal government freezing states and locals out of an investigation in a case that the federal government does not intend to fully investigate itself. And I think you phrased the question just right, by the way, Allison. What can we do? I mean, I think that this is something where we've already seen that public protest, public focus on this issue is the only thing that can bring this administration to heel. And I know, if you're like me and you've got a couple of red state senators who you think don't listen to you, it gets old to stay in touch with them. Tomorrow is going to be the day to pick up your phone and call these guys and demand, because we have already seen on the Sunday shows, there were a few Republicans who were willing to come out and say there needs to be a full investigation. We need to tell them, you'll pardon my French, this has been a long weekend, not a bullshit investigation. This needs to be a real investigation. And sometimes you'll hear folks in law enforcement talk about big, important cases where the feds and the state and local guys set up a task force and work together. We've done that in Birmingham repeatedly. We did it for the 16th Street church bombing when we prosecuted that as a cold case. We did that in a case that I worked on, the Birmingham abortion clinic bombing with Eric Robert Rudolph, who was convicted of that bombing and a couple of bombings in Atlanta, including Centennial Park during the Olympics. Those are big, full-on efforts where you have rooms full of folks from all of the alphabet agencies. The bomb dogs are there, the tech guys are there, the state and local guys are there, prosecutors are there, and everybody's working together on those big cases. That's one thing. It is routine for us in our day-to-day business as federal prosecutors to work all the time with state and local prosecutors. Have a drug case, the feds take sort of the kingpins, the state prosecutors do the cases that are centralized in their area that they're better able to take care of. Have a violent crime, feds are always going to work with their state partners who are better equipped to do homicide cases. We work together every day. It's our bread and butter. And the idea that you would tell folks to pack up and go home at a crime scene like that involves one of their citizens is completely off the rails. And in and of itself, it suggests that this is not legitimate, right? If DHS was going to do a legitimate investigation, they would have invited the state folks to stick around. But the reality is that DHS does not investigate officer-involved shootings. To the extent that that's done in the federal government, it's almost exclusively done by the FBI. And so here, when an agency that is not equipped to do this, that doesn't have a trajectory of doing this, suggests that they'll do it, it's not very difficult to smell cover up.
Right, especially after they've already made their, assertions that this was a domestic terrorist who brandished a gun and was going to do maximum damage and massacre law enforcement or whatever Bovino said. But you're right. Bovino was raked over the coals by Bartiromo on Fox today. He was Dana Bash, who's
Yeah.
usually very moderate, was questioning him and kept bringing up that Orwellian concept of "We saw this with our own eyes, sir."
Hey, can I just add to that, by the way, because I've done a number of cases involving officer-involved shootings, and one of the things that I know to be true, you always learn from your own mistakes the best. I had a case, and it was not that long ago, maybe 15 or 16 years ago, where we had some initial video, and it looked to me like it was what law enforcement would call a bad shoot. The language is a little bit crass. Bad shoot, one that violates the law. Good shoot, one where the officer was justified. So forgive me for using the language that's used. But in this case, from early video, it looked like there was a problem. And then we got more video like a week later, a long time later, and it gave more perspective. And you could actually see very clearly what the officer saw and that he was, in fact, acting to protect bystanders, which was what we had been told. But from the early video, I was very skeptical. And so something that you learn to do is wait. You don't come out and make a statement 2 or 3 hours later saying, this was a crazy domestic terrorist who wanted to massacre law enforcement. But that's what we heard DHS do here. They have lied to us twice. And I'm of the school that says, fool me once, shame on you. Fool me twice, shame on me. There's no reason to take what these folks are saying at face value. They're going to investigate to bootstrap their own conclusions. But look, you guys, we can watch video. We can see when a gun is taken off of a gentleman who is entitled to carry that gun. There is a Second Amendment, no matter what DHS is telling you today. The gun is gone before he's shot. And you can see the shooter. It appears to me, and again, it's worth waiting to see the video and the enhanced video and hear from witnesses, but it looks like the shooter is the same guy who's shoving the woman who the victim, Mr. Pretti, is trying to assist. And it looks like the agent, after that woman is taken out of his purview, is sort of angry and he turns around and pulls his gun, bam, bam, bam. And that is an unjustified use of deadly force by a member of law enforcement. It's something that demands prosecution, both for justice in the one case, but also to deter future instances. And we are now at this dangerous inflection point where leadership in this administration is telling agents it's okay to shoot protesters. That's really what this is all about at this point. So keep up the protesting, keep up your activism, and call your senators and your members of Congress and your governors and let them know you're incensed about this and you're not going to let it go.
Yeah, agreed. Cameras out, right?
You
Canada
bet.
says
All the
elbows
time.
up. I say cameras out. Thank you so much for answering some of these really difficult questions for us today. We're going to keep our eyes on this. More video is going to come out, more things, more information is going to happen. We're going to keep our eye tomorrow or on Monday, I should say, on that hearing for the temporary restraining order to preserve the evidence. And maybe the next steps are to get a warrant to get that evidence. And we'll see how the DHS responds. I don't think it'll be in a way that we would like, but
It's hard to imagine them turning the evidence over without a fight, but you never know. A federal judge telling the Justice Department to do something occasionally yields benefits.
sometimes it does. Thank you so much. Everybody, please subscribe to Civil Discourse. You all know Joyce Vance. Make sure you subscribe to her Substack. And if you're able to, you can subscribe to The Breakdown, my Substack as well. I really appreciate your time today. Joyce Vance.
Thank you so much for having me. I am a huge fan of The Breakdown, and you all should subscribe.
Oh, thank you so much. Everybody, we will see you next time.
See you soon.